ಶಶಿ.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಕಾನೂನು ಕುಡ್ಲ ವೆಬಿನಾರ್ ಗ್ರೂಪ್ನ ಮತ್ತೊಂದು ಸರಣಿಯಲ್ಲಿ ನಾವಿದ್ದೇವೆ. ಇವತ್ತು ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಾಗಿ ನಮ್ಮೊಂದಿಗೆ ಇರುವವರು ಮಂಗಳೂರಿನ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳಾಗಿರುವಂತಹ ಶ್ರೀ M.P.Noronha ಅವರು. M.P.Noronha ಅಂದರೆ ಮೆಲ್ವಿನ್ ಪ್ರಕಾಶ್ ನರೋನ್ ಅವರು. ನಾವೆಲ್ಲರೂ ಅವರನ್ನ ಪ್ರೀತಿಯಿಂದ MP ಅಂತ ಕರಿತೇವೆ. ಅವರೊಂದು ಅದ್ಭುತ ವ್ಯಕ್ತಿತ್ವ. ಅವರ ಬಗ್ಗೆ ಎರಡು ಮಾತು ಹೇಳಬೇಕು ನಾನು. ಅವರು ಹಲವಾರು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ಗಳಲ್ಲಿ, ಹಾಸ್ಪಿಟಲ್ಗಳಿಗೆ, ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ಗಳಿಗೆ, ರಿಲಿಜಿಯಸ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಗಳಿಗೆ ಎಲ್ಲದಕ್ಕೆ ಅವರು ಲೀಗಲ್ ಅಡ್ವೈಸರ್ ಆಗಿದ್ದಾರೆ. ಅದರ ಜೊತೆಗೆ ಮಂಗಳೂರು ಯೂನಿವರ್ಸಿಟಿಯಲ್ಲಿ ಸಿಂಡಿಕೇಟ್ ಮೆಂಬರ್ ಆಗಿದ್ದವರು 3 ವರ್ಷಗಳ ಕಾಲ. ಆ ಟರ್ಮ್ನ ನಂತರ ಮತ್ತೆ ಅಕಾಡೆಮಿಕ್ ಕೌನ್ಸಿಲ್ಗೆ 3 ವರ್ಷಗಳ ಕಾಲ ಮೆಂಬರ್ ಆಗಿದ್ರು. MCC ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಚೇರ್ಮನ್ ಆಗಿದ್ರು. ಇದು ಮಾತ್ರ ಅಲ್ಲದೆ ಅವರ ಪ್ರೊಫೆಷನಲ್ ಲೈಫ್ ಸ್ಟಾರ್ಟ್ ಆಗೋ ಮುಂಚೆ ಅವರು ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಟೈಪಿಂಗಿಗೆ ಫಸ್ಟ್ ರ್ಯಾಂಕ್ ಹೊಡೆದವರು. ಅದರ ಜೊತೆಗೆ BA ಲಾ ಮತ್ತು LLB ಎರಡರಲ್ಲೂ ರ್ಯಾಂಕ್ ಹೊಡೆದವರು. ಅಂತ ಒಂದು ವಿಶಿಷ್ಟ ಪ್ರತಿಭೆ ನಮ್ಮ ಜೊತೆ ಇದ್ದಾರೆ ಇವತ್ತು. ಬಹಳ ಮುಖ್ಯವಾಗಿ ಅವರು ಕ್ರಿಶ್ಚಿಯನ್ ಮ್ಯಾರೇಜ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಗಿದ್ದಾರೆ, ನಾಟ್ರಿ ಅಡ್ವೊಕೇಟ್ ಆಗಿದ್ದಾರೆ. ಕಳೆದ 31 ವರ್ಷಗಳಿಂದ ಅವರು ಕಾನೂನು ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದಾರೆ ನ್ಯಾಯವಾದಿಯಾಗಿ. ಇವತ್ತು ಕ್ರಿಶ್ಚಿಯನ್ ಲಾದ ಬಗ್ಗೆ ನಮಗೆ ವಿವರವಾಗಿ ತಿಳಿಸ್ಲಿಕ್ಕಿದ್ದಾರೆ. ಕಾನೂನು ಕುಡ್ಲ ಗ್ರೂಪ್ನ ಪರವಾಗಿ, ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ, ಈ 2 ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ನ ಎಲ್ಲ ಸದಸ್ಯರ ಪರವಾಗಿ ನಾನು ಅವರನ್ನ ಪ್ರೀತಿಯಿಂದ ಮತ್ತು ಆತ್ಮೀಯವಾಗಿ ಸ್ವಾಗತಿಸಿದ್ದೇನೆ. ವೆಲ್ಕಮ್ ಯು ಸರ್. ವೆಲ್ಕಮ್.
ಥ್ಯಾಂಕ್ ಯು. ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಲಾ?
ಎಸ್ ಸರ್, ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
ಎಲ್ಲರಿಗೂ ಗುಡ್ ಈವ್ನಿಂಗ್. ಕಾನೂನು ಕುಡ್ಲ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನು ಆಯೋಜಿಸಿದ್ದು, ಅವರು ಮಾಡಿದಂಥ ವಿವಿಧ ವೆಬಿನಾರ್ಗಳನ್ನು ನೋಡಿದ್ದೇನೆ. ನಮಗೆಲ್ಲರಿಗೂ ಒಂದು ಉತ್ತಮ ಅವಕಾಶವನ್ನು ನೀಡಿದ್ದಾರೆ. ಇವತ್ತು ನನಗೊಂದು ಅವಕಾಶವನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ತಮಗೆಲ್ಲರಿಗೂ ಥ್ಯಾಂಕ್ ಯು ಅಂತ ಹೇಳುತ್ತಾ, ಈ ಕ್ರಿಶ್ಚಿಯನ್ ಲಾ ಬಗ್ಗೆ ಕೆಲವೊಂದು ಮಾಹಿತಿಯನ್ನು ತಮ್ಮೊಳಗೆ ಹಂಚಲಿಕ್ಕೆ ನಾನು ಈಗ ಉತ್ಸುಕನಾಗಿದ್ದೇನೆ.
ಒಂದು ನಿಮಿಷ ಸರ್, ಒಂದು ನಿಮಿಷ ನೋಡಿ. ಪದೇ ಪದೇ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ವಿಡಿಯೋ ಆನ್ ಮಾಡಬೇಡಿ ಅಂತ. PA ಥಾಮಸ್ ಕೋಟೇರಿ, ದಯಮಾಡಿ ನಮ್ಮ ವಿಡಿಯೋ ಆಫ್ ಮಾಡಬೇಕು. PA ಥಾಮಸ್. ಎಸ್, ಮುಂದುವರಿಸಿ ಸರ್.
Initially, British government enacted Indian Succession Act 1865 for Christians. Today I will be dealing with succession, marriage and the divorce. These 3 things I will be dealing today. This British Government Act of Succession Act 1865 was repealed and Indian Succession Act 1925 was brought into force. Now, so far as Christians are concerned, they are governed by, as far as succession, 1925 Indian Succession Act, they are governed by it. There are 2 types of succession. One is testamentary succession, other one is intestate succession. So far as testamentary succession is concerned, my friend DLA has already dealt with it. Today I'll be dealing with the aspect where will is not made in respect of those properties, how the properties will be devolving among the Christians. Now there is a lot of difference between Hindu succession, Muslim succession and a Christian succession. Say for example, under the Hindu law, for if a male dies, they are governed by section 8 of the Hindu Succession Act. There is a separate legal acts. If female dies, they are governed by section 15 of the Hindu Succession Act. But so far as Christians are concerned, whether a male dies or a female dies, in both cases succession is the same. Whether is a daughter, whether is a son, the rule of succession or everything is same. Under the Muslim law, son gets doubler than the daughter. If the daughter is for one share, the son will get 2 shares. But among the Christians, son will have 1 share and the daughter will have also 1 share. Before I go through the provisions of the Succession Act, let me explain the basic principles which we have to always remember. The first thing is that there is no concept of joint family. Joint family property concept is not prevailing among the Christians. Therefore, even if I inherit the property from my father, grandfather, great-grandfather, in my hand, it is as good as my self-acquired property. My children don't have any right as long as I am alive. So, concept of ancestral property or a joint family property is not applicable. That is all consistently held by Karnataka High Court, Supreme Court. All the decisions are very, very clear. Now, we find many a times we come across a partition deed being executed during the lifetime of the father between the father and the children. Now, this type of partition deed has been declared as null and void by the Karnataka High Court as well as the other courts. So, therefore, any partition deed which is executed during the lifetime of a person between himself and his children is non-est and a void document and law. This is the first thing which we have to remember. No concept of ancestral property. Second, males and females are all same. Therefore, whatever I say in case of a male person or a son or the husband, same is applicable for the whatever is applicable to the son is applicable to the daughter. What is applicable to the husband is applicable to the wife, and whatever is applicable to the wife is applicable to the son. All are same, similarly situated. Point number 3. Among the Christians, between the same degree of relationship, they are entitled to have a share per capita. That is, each heir is equal and in the same degree they are entitled to an equal share. Suppose the relationship is not equal degree, in that event they are taking per stripes. Per stripe means assets are divided equally by the branch of the legal heir. Now, point number 4, the domicile of a person plays an important role so far as the succession is concerned. As far as the immovable property is concerned, which is located within India, the Indian Succession Act is applicable because the property is situated in India. But so far as movable properties are concerned, whatever or wherever the person's domicile at the relevant point of time, that country's law will prevail and not the Indian law. Suppose I have got an Indian citizenship, I have got a property here, but I have domicile at England. If I die at England, where I have a domicile, then my movable properties will be divided as per the law prevalent in the Britain, and my immovable properties will be divided as per the law prevailing in India. Now, point number 5, Act, that is Indian Succession Act, recognizes 3 types of heirs. First is spouse, second is lineal descendants, third is kindred. Now, when a husband dies, wife would be entitled only if they have children, only 1/3 right the wife will be entitled. If there are no children, wife will be entitled half share. And if the lineal descendants also not there, then kindred also not there, then the entire estate will be inherited by the wife. Now, I have disclosed the map here. If suppose, let us assume the husband was owning 90 cents of land. If he dies, suppose he has children or grandchildren, then at the time of death, if the wife is alive, she will acquire only 1/3 right. She will be entitled to 30 cents of land. If wife has no children or grandchildren living at that time, no lineal descendants, then she will be entitled to 50%. That means 45 cents she will be entitled out of 90 cents. Now, if not only that person has no children or grandchildren, but he has no father, mother, brothers, children and all, no kindred, in that event, the wife will be entitled to the entire estate of the property. This is where I see a lot of confusion among the people. When under the Hindu law, even if when the son dies, even if the son has got wife and children, one share will go to the mother, but no share is given to the mother. Or in case of Hindus, if he has got wife and children, if he has got only wife, no children, no mother, then the wife will be entitled to the entire estate. But not here. Here only 50% will go to the wife if there are no children. This is one so far as a spouse is concerned. Next, can you ಎಲ್ಲರಿಗೆ ಕಾಣ್ತದೆ ಇದು?
Yes, ಕಾಣ್ತಾ ಇದೆ.
Yes. Then second is lineal descendants. Now, before coming to this aspect of lineal descendants, one has to remember that child means only legitimate child. Illegitimate children are not recognized under the Indian Succession Act. Of course, in only one of the decision before the Kerala High Court, where motor vehicle compensation is to be distributed, in Jane Anthony case, there they considered the right of a illegitimate child also for the purpose of Motor Vehicles Act, but they suggested to the government a amendment requires to be made to the Indian Succession Act to include illegitimate children also. But so far as law stands as on today, to the best of my knowledge, these illegitimate children are not entitled to any share. Only under section 21 of the Indian Divorce Act, it says that even if the marriage is declared as null and void for the reason that the spouse had one more spouse living at the time of marriage, only in such events, if the person contracted the marriage in a bona fide faith that he has no other spouse, in that event, the children born out of that wedlock will inherit the share of the father. Similarly, if the marriage is declared as void for the reason that the other spouse is lunatic, in that event also, children born in that said wedlock before the marriage is declared as null and void, then only those children will inherit the property. Otherwise, if the marriage is void, in that event, the children will not have any right. Now, that for that purpose, let me take your attention that we are governed by the Indian Christian Marriage Act. Indian Christian Marriage Act is concerned. It says when the marriage is valid and when the marriage is not valid. If as per section 60 of the Indian Christian Marriage Act, if basic condition is that 21 years of marriage for the male and 18 years of age for the female, then the spouse should not be living at the time of marriage. Section 19 of the Indian Divorce Act says, in the case of a person is impotent at the time of marriage, in that event, that person is entitled to seek a nullity of marriage. One more ground, an important ground of declaring marriage as null and void is that when the persons are within the prohibited degrees of relationship. Now, what is prohibited degrees of relationship is not defined under the Indian Divorce Act. For that purpose, we have to seek the personal law of that particular denomination. Say, for example, Catholics are concerned, they are governed by law known as canon law. Now, this canon law is concerned, the Supreme Court as well as the other high courts have consistently held that canon law is applicable to the Roman Catholics, because it is just like, suppose you are a member of a club, a Rotary Club, Lions Club and all. In that event, you are bound by the rules and regulations of that club. Similarly, as far as Roman Catholics are concerned, they are governed by the provisions of canon law in respect of all matters where there is no particular statute. So, Supreme Court in the year 1972, at page 2667, in that decision, Supreme Court said, because consanguinity is not near prohibited degree, relationship is not mentioned under the Indian Divorce Act, canon law can be looked into, and the court said, as per canon law, if the marriage is not valid, then it is not valid. If it is valid, then it is valid. Now, the canon law says, as per the canon law, impediment of marriage is, if you are related directly by consanguinity, then either ascending order or descending order, direct father, daughter, granddaughter, etc., then that marriage is void under law. So also, marriage under the collateral line, brothers, children, sisters line, to that till 4 degrees, the marriage would not be valid. However, the church can grant exemption in certain cases. In that case, after 2 degrees, the church has got authority to grant an exemption. In that case, the such marriages would be valid. Now, so far as marriages are concerned, Christian marriages are concerned, Section 4 of the Christian Marriage Act says, every Christian, either of one, at least both, when they are Christians, shall marry under the Indian Christian Marriage Act. Otherwise, marriage is not valid. Subsequently, the Special Marriage Act is brought into force. Therefore, even under the Special Marriage Act, if a Christians get married, their marriage will be valid. The children will be validly recognized as legitimate children. So, for the purpose of the succession also, marriage, a valid marriage is important. Under the Christian Marriage Act, marriage could be solemnized by the priest or the persons who are holding licenses, or by the registrar of marriage. If it is a registrar of marriage, churches are concerned, we may not be much interested, because they are dealt by the church priest and all. So far as registrars of marriage is concerned, they are appointed by the state government. Just like for Hindu Marriage Act, the sub-registrar is appointed as a marriage registrar, or under the Special Marriage Act, sub-registrar is appointed as the marriage officer. Similarly, for the Christians, the state government can appoint a Christian marriage registrar, and any couple who is intending to marry, they can issue a notice to the Christian marriage registrar. That notice has to be published. After publishing the notice, after waiting for sufficient time, and if there is no impediment, in that event, the certificate can be, notice certificate can be given by the marriage registrar. After taking oath from the parties, there is no impediment for the marriage. Only thereafterwards, he can register the marriage. Second option for the marriage registrar to register the marriage is that church marriages are being done by the priest. They bring that certificate with the marriage registrar. They register the marriage. This is what is provided under the Christian Marriage Act is concerned. Now, these aspects are relevant for the purpose of deciding the legality of the child who is entitled to succeed. So far as the adopted children are concerned, Karnataka High Court, Kerala High Court have said, adopted children are equally entitled as any other legitimate children. They are recognized as legal heirs. Now, with this, law says, so for Indian succession, how it has to be divided. The law says, if 1/3 goes to the wife, as stated earlier, remaining 2/3 will be shared equally between the parties, between the children. For example, I've given one example. Let us assume husband had 90 cents of property. 1/3 share is given to the wife, 30 cents. Remaining 60 cents of land is there. 4 children are there, 2 sons, 2 daughters. Each will be 2/3 being divided between the 4 children equally. Therefore, all these 4 children will be equally entitled to remaining 2/3 share, and therefore each are entitled to 15 cents. Next example, suppose there is only one child, no other children, only one child. Then also wife will be entitled only to 1/3 share, that is 30 cents. Here there is a typographical mistake, it should be 60 cents. The son would be entitled to 60 cents. Wife 30, son would be entitled to 60 cents. 2/3 the sole child will be entitled to. In the next example, here we see wife will be entitled to 1/3 share. 2 sons and 2 daughters were there. One daughter had predeceased their father. Therefore, her 15 cents right will devolve on the 3 children. Remember, it will be her share will be devolved among only the lineal descendants, the children, and not to the husband of D. So, husband of D is not entitled to any share if the daughter had, or the son, as the case may be, had predeceased the father. Next example. Here we see another where all the children are dead. Let us assume all the children are dead and wife is alive, only grandchildren are there. In that event, after deducting 1/3 share of the wife, this grandchildren, you may note, the first son had, let us assume 2 children, he had grandchildren. Then the second son had also 2 children. Then third had 2 children, and the fourth had 2 children. Here the diagram shows 8 children. Then the 60 cents will be divided between 8 children. While drawing the diagram, let us assume the S had, let us assume S had 4 children. First son had 4 children. Then the total would be 10 children. Then the remaining 60 cents would be divided between all the 6 children, 6 cents each. So when the first degree is not there, only grandchildren are there, all the grandchildren are taking equally their share. Next example. Now, suppose if lineal descendants are not there, grandchildren are not there. Now, after deducting the share of the spouse, that is 1/3, if there is a spouse, or if a person dies as a bachelor, or if a person dies as a spinster. Now, this will be the rule. The entire property would go to the father. If he is alive, entirely the property would go to the father. Mother will not get any share. Brothers and sisters will not get any share. Next, suppose, let us assume father is dead. In that event, mother and brothers and sisters will get, all are equally entitled to the share. In this example, there is a mother, there are 2 brothers, 2 sisters. Since father is dead, if father was alive, entire would go to the father. Since father is dead, mother would be entitled to 1/5, brother would be entitled to 1/5, another brother 1/5, 1/5, 1/5. So this is how the shares will be divided. Suppose no brothers and sisters or no nephews, no nieces. In that event, entire property, if the mother is alive, entire property would go to the mother. Then, if, let us assume, the father is dead, mother is alive, brothers and sisters are there, one of the brother had predeceased the father. Here, daughter-in-law will not get the share of that predeceased brother. That 1/5 share will be divided between his children, lineal descendants only, and suppose there are 3 children, each would be entitled to 1/15 share. So each have only their lineal descendants will have the right, not the daughter-in-law or the son-in-law, as the case may be. Therefore, this is in nutshell what is Indian Succession Act says about the shares. Then I am dealing in short Indian Divorce Act.
ಸರ್
So far as
ಒಂದು ನಿಮಿಷ ಸರ್.
yes, yes.
ಸಾರಿ ಫಾರ್ ದಿ ಇಂಟರಪ್ಷನ್. ಈಗಾಗಲೇ ನಮ್ಮ ಈ ವೆಬಿನಾರ್ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರಾದಂತಹ ಜಾನ್ ಮೈಕಲ್ ಡಿ ಕುನ್ನಾ ಇವರು ಪಾಲ್ಗೊಂಡಿದ್ದಾರೆ. ಇವರು ಮಂಗಳೂರಿನಲ್ಲಿ ತಮ್ಮ ವೃತ್ತಿಯನ್ನ ಪ್ರಾರಂಭ ಮಾಡಿ ಎಜೆ ಮಥಾಯಿಸ್ ಇವರೊಂದಿಗೆ ತಮ್ಮ ಪ್ರಾಕ್ಟೀಸ್ ಅನ್ನ ಪ್ರಾರಂಭ ಮಾಡಿ ತದನಂತರದಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಆಗಿ ನಿಯುಕ್ತಿಗೊಂಡ್ರು. ತದನಂತರದಲ್ಲಿ ಹೈಕೋರ್ಟ್ನ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಗಿ ನಿಯುಕ್ತಿಗೊಂಡು ನಂತರ ಹೈಕೋರ್ಟ್ನ ನ್ಯಾಯಾಧೀಶರಾಗಿ ನೇಮಕವಾಗಿ ಈಗ ಕಳೆದ ತಿಂಗಳಷ್ಟೇ ಇವರಿಗೆ ನಿವೃತ್ತಿಯಾಗಿದೆ. ಈಗ ಅವರು ಈ ವೆಬಿನಾರ್ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನಮ್ಮೊಂದಿಗೆ ಪಾಲ್ಗೊಂಡಿದ್ದಾರೆ. ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ ಹಾಗೇನೆ ಕಾನೂನು ಕುಡ್ಲ ವತಿಯಿಂದ ನಿಮಗೆ ತುಂಬು ಹೃದಯದ ಸ್ವಾಗತವನ್ನ ಬಯಸ್ತಾ ಇದ್ದೇವೆ. JMD ಕುನ್ನಾ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್
ಸರ್, ಈ ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ಒಂದು ಎರಡು ಮಾತು ಹೇಳಿದ್ರೆ ಉತ್ತಮವಾಗಿತ್ತು.
ಬೇಡಪ್ಪ, ಅವರು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಲಿ ಅವರು. ಇನ್ನೊಮ್ಮೆ ಎಲ್ಲರನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತಾಡುವ, ನೋಡುವ ಸಂದರ್ಭ ಬಂದ್ರೆ.
Okay, thank you.
Let us not break the continuity of his thought. I think let him go on. I think that would be better. So thank you. Thanks for the welcome. Yes, sir. Right.
Yes, thank you, sir. Yes, Noronha sir. Continue.
So far as Christians are concerned, they are governed by the provisions of Indian Divorce Act. Before the amendment of the year 2001, only one ground of divorce was available, that was adultery. For suppose if the wife wants to seek the divorce, in that event she had to prove adultery coupled with the desertion, adultery coupled with the cruelty, all those things. After the 2001 amendment, now the law has been changed. It is just like Hindu law only. Similar grounds are provided as Special Marriage Act provides. Similar grounds are provided. Anyhow, I'll be dealing with in brief those grounds. Adultery, there is one important feature in this Indian Divorce Act. Suppose you are pleading a ground of adultery, then you have to make adulterer as a party to the proceedings. If adulterer is not made as a party to the proceeding, when the husband presents that petition, if the wife is leading a life of a prostitute, that is an exception. Second is, in spite of his best efforts, he is not able to trace out who is that person. In that event, that there is an exemption. So also, if that person is dead or unknown, in such an events that you need not make the adulterer as a party. Then other grounds are when the respondent has ceased to be a Christian by way of conversion, when the respondent is suffering from incurable unsound mind of not less than 2 years, then other ground is when the respondent is suffering from virulent and incurable form of leprosy not less than 2 years prior to the presentation of the petition. If the respondent is suffering from venereal disease in a communicable form for more than 2 years, then if the respondent is not heard of for a period of more than 7 years, then the other ground is if the respondent has willfully refused to consummate the marriage and the marriage has not been consummated, then other ground is there is a restitution of conjugal decree, but that has not been complied with. In that event, other last ground is last two grounds. One is desertion for more than period of 2 years. Other ground is cruelty. Now, so far as this cruelty is concerned, Hello. So far as this cruelty is concerned, one important aspect you have to notice, under the Hindu law, it is sufficient to prove the cruelty. But under the Christian law, that is the Indian Divorce Act, cruelty should be such an extent to cause a reasonable apprehension in the mind of the petitioner that it would be harmful or injurious for the petitioner to live with the other party. This is the basic difference. So far as mutual divorce by mutual consent is concerned, it is available in both Hindu law as well as in the Christian law. But under the Christian law, 2 years period is mentioned. But the high courts have consistently held that 2 years period is not correct. 1 year is sufficient. If they are separated, they can present a petition for divorce on mutual consent. The other ground available for the wife is exclusively for the wife. Those grounds are available. That is when the husband is guilty of rape, sodomy, and bestiality. These are the important features of so far as divorce is concerned. Then judicial separation is also recognized on 3 grounds. That is adultery, cruelty, and desertion for more than 2 years. One can obtain a judicial separation. Now, one important factor is that if wife obtains a judicial separation, or even husband obtains a judicial separation, then if husband dies, wife will be entitled to a share. But if the wife dies, husband will not be entitled to any share. That is what under section 24 of the Indian Divorce Act is provided. That is, for the women, there is an if after separation, judicial separation, if she dies, then the husband would not be entitled to any share. Then so far as restitution is concerned, that is available under Hindu law. So similarly, it is available under the Christian law also. Similar grounds as in other law, very same grounds are available. Then so far as alimony is concerned, interim alimony is provided under the Indian Divorce Act as well as in the other laws, Hindu Act. But so far as permanent alimony is concerned, there is one important provision. That is, section 37 says, only when wife has presented the petition for judicial separation or dissolution, then she can be granted maintenance. Section is silent. It nowhere says if the husband has filed the petition and the husband isn't able to get the divorce decree or judicial separation decree, in that event also, wife is entitled for a permanent alimony. Such provision is not there in the legislation. However, in the year 2015, the Karnataka High Court said such a distinction is not valid. And even if the husband has obtained a divorce, had filed the petition and obtained the divorce against the wife, stating that either she is cruelty or on the ground of adultery or any grounds, even then the matrimonial court or family court can pass a maintenance order in favor of the wife. This in brief, I have dealt with all the 3 acts because the time provided I had to conclude within between 30 to 45 minutes. I have done it. I am thankful to the Kanun Kudla team for providing this opportunity. They are doing very well and I appreciate their work. I thank all of you for patiently listening to me. Thank you.
Yes, thank you, sir. There are certain questions in chat box. I will read out all these questions. And before that, if Dikuna sir is present, kindly please 2 words. Dikuna sir.
I think it is a well presented lecture. I think he has tried to summarize the salient aspects of the Christian law, both with to the succession as well as marriage. Of course, some more aspects are there, I think, which require further what you call exposition, which I think this what you call the program that you have arranged, I think it gives a fillip or a trigger for you to further discuss, because what could be covered in 1 hour, may not be sufficient because there are other aspects also which are required to be dealt with, some finer aspects touching with the legal, because how each section has been construed by the court with the emphasis to the Christians. And I think that exercise may have to be done by the advocates themselves. But as a introduction to the subject, or the emphasis given to the subject by emphasizing the salient features of it, I think Mr. Noronha has covered almost all the aspects, and I must congratulate him. And I must also congratulate the youngsters. I think it is this exercise, I would say, should have been done long back. I think very many bar associations are far ahead. We have started, though it is late, but it is, I think, especially we don't realize the usefulness of it now. But when the real problem comes, I think what has been discussed, immediately we can fall back upon it. We can discuss with the advocate or the resource persons who has touched upon that subject. Everyone may not be in a position to touch upon every subject. So in that way, I think these seminars or webinars are of very much use. And of course, even without that, our youngsters are doing well. I think the youngsters, what steps that you have taken in this direction, I must congratulate all the members of the Bar Association of Mangalore. So thank you very much. Wish you all the best.
Thank you, sir, for your inspirational words. Now I will proceed with the questions. I will read out the questions, sir. Now the first question by Nikesh Shetty: whether canon law permits adoptions of child?
Yes, canon law recognizes adoption of a child.
Yes. Next question, Guru Prasad: whether Syrian Christian and Protestants and other Christians other than Roman Catholics are governed by Indian Succession Act?
Yes, all of them are governed by the Indian Succession Act only. All denominations.
Yes. Next question by Banu Shankar: sir, if a Christian lady marries a Hindu, whether she entitled to the share in her father's property?
Yes, even though she has married to Hindu, her right will not go. She is entitled to the share in the father's property.
Yes. Next question.
If I have to interfere there regarding adoption,
Yes.
I think the settled law under a Christian law, it does not recognize adoption. But of late, I think you may be knowing it. I think our High Court in Joyce Puspalata Karkada versus Mrs. Shamila Nina, where by following the earlier decisions and mainly from the Kerala High Court, what it has said is that Christian law does not recognize adoption, but it is an admitted fact that the Christian law does not prohibit adoption. I think on that reasoning, this our High Court has said even it has upheld the adoption. Otherwise, as a first principle, I think adoption as such was not recognized under Christian law. But Kerala High Court has given consistent decisions. I think I have got another decision here, that is Phillips Alfred Malvin versus Y.J. Gonsalves and others. That is AR 1999 Kerala 187. And the earlier one, that reported citation I don't have here. Earlier decision, that is of 2013 from our High Court. I think there are two decisions which say that there is adoption is also recognized by the courts now. Yes, I think that the canon law, of course, as Melvin has said, canon law does not prohibit adoption, and based on that, because of this personal law, the courts have of late have given recognition to this. I think that is one aspect you must keep in mind with reference to the decided case laws of the High Court and of the Karnataka High Court and the Kerala High Court.
Yes. Thank you, sir, for your clarifications. Now I will go for the next question by Guru Prasad. Are any heirs qualified on the grounds of conviction for murder or accepting priesthood becoming a nun or becoming a nun?
Suppose a person becomes a priest or a nun, his share is not defeated. He is always entitled to a share. There is, of course, decision of the Karnataka High Court also, where it is said, even if a person has become a nun or a priest or a joint religious order, they are equally entitled to the share.
Yes. Next question by Guru Prasad. Is divorcee entitled to share?
Divorcee is not entitled to the share in the property of her husband because marital relationship has broken down and there is no husband and wife relationship.
Yes. Next, the same
Second.
continuation question. It is not getting the correct word.
No, that is, yeah,
mother,
unwed
which
mother. Unwed
yes,
mother, they are
mother
entitled
entitled to
to
be
the appointed as
guardian.
a guardian. Guardian of whom is the question? Because so far as the unwed mother is concerned, she herself is the natural guardian. And there is no special appointment is required so far as her child is concerned. Only if it is a case of where there is a marriage, the father becomes the father becomes the natural guardian. Mother is also natural guardian. But in the case of unwed mother, she is already a natural guardian and there is no bar to be appointed as her guardian for any purposes.
Yes. Next question by Guru Prasad Shetty. How is succession role in joint cultivation of declaration property?
It is a good point. Suppose even if they are Christians, suppose father is the original tenant and that property is, he dies before 1974. In that event, all the children who are cultivating the property are entitled to the share. Of course, there are decisions which say if the daughters were given in marriage prior to 1974, they are not entitled to the share in the property because they were not cultivating it. There is one more aspect in this. So far as Christians are concerned, there is no concept of joint family. Under the Hindu law, there is a concept of joint family. Therefore, consistently, High Court and Supreme Court has said, if one of the member is cultivating the property, everyone is having the share. But most interestingly, under the definition of Karnataka Land Reform, under the Karnataka Land Reforms Act, joint family is defined. In the case of non-Hindus, in the case of Hindus, joint family. In the case of non-Hindus, where they are joint in estate or joint in residence. So if we are able to prove that they were joint in residence or they were joint in estate, when the Land Reforms Act came into force, all the children will be equally entitled.
Yes. Next question by. So before that, ನಮ್ಮ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕಡ್ಲೂರು ಸತ್ಯನಾರಾಯಣಾಚಾರ್ಯ ಇವರು ಕೂಡ ಪಾಲ್ಗೊಂಡಿದ್ದಾರೆ. ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ ಮತ್ತು ಕಾನೂನು ಕುಡ್ಲ ಈ ವೆಬಿನಾರ್ ಗ್ರೂಪ್ ನ ಪರವಾಗಿ ತುಂಬ ಹೃದಯದ ಸ್ವಾಗತವನ್ನ ಕೋರ್ತಾ ಇದ್ದೇನೆ. ಕಡ್ಲೂರು ಸತ್ಯನಾರಾಯಣಾಚಾರ್ಯ. ಬಹುಶಃ ಈಗ ಲೈನಲ್ಲಿ ಇದ್ದಾರ ಗೊತ್ತಿಲ್ಲ. Yes, I will move to the next question by Guru Prasad Shetty. How is succession? That is over.
That
Next,
is over.
S.S. Acharya. Kotari, S.S. Kotari. Can adopted child is treated as same as legitimate child as a matter of succession?
Yes, as Mr. Justice Dikuna said, as per the recent rulings of the Karnataka High Court and the Kerala High Court, a adopted child is treated as same as legitimate child. Earlier, such recognition was not there. Now it is being recognized. Especially, I had studied under the Juvenile Justice Act also. Anybody can adopt the child. Because of that Juvenile Justice Act, there is a lot of changes now. Even Christians can adopt, Muslims can adopt. And there are umpteen number of decisions where it provides that a adopted Christians can adopt the child and they inherit it. In Mangalore court only there was one case where a father, parents had adopted one child from other family. Then all of a sudden, after a few years, that child wanted to go to the original parents. And the original parents took them. Then the child welfare committee intervened. When the child welfare committee intervened, the parents said, no, no, this is our child, we want it. And the child welfare committee also said, no, 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 this has to go to the natural parents only, because among the Christians there is no concept of adoption. Then the revision was filed before the district court Mangalore, and the district court also held adoption is valid. There is no bar among the Christians not to adopt the child. Therefore, the adopted father and mother are entitled to have the custody of the child. If the natural parents have got any right, they have to file a separate legal proceedings.
Yes. Next, Mr. Guru Prasad has posted the citation which has been stated by Justice J.M.D. Kunna. So you can refer
Yes.
our group also. So those who are viewing now, you can view that citation. And next question by Sanjay Rao. Will a Christian who gets converted to other religion lose right in his father's property?
No, he will not lose his right merely because he is converting to the other religion, because he has already got that right, and that right cannot be lost merely because he has converted to the other religion.
Yes. Next question by Nikesh Shetty. Whether section 125 of CRPC is applicable to divorcee Christian wife?
Yes, it is applicable to all, and they can seek maintenance under section 125 of the CRPC.
Yes, again, Mr. Guru Prasad posted that AR 1999 Kerala 187, referred by Justice J.N.D. Kunna. Next, Bhanu Shankar. What is the process of a valid adoption?
Now, this is a very good question, because nowhere the canon law says how you can adopt the child. Statute is also not there how we can adopt the child, except the Juvenile Justice Act. When I have studied that Juvenile Justice Act, I have gone through some of the decisions where you can adopt the child directly also, provided you are getting an order from the court. In the last case which I referred, which has been decided in the Mangalore District Court, there they had done the this one direct adoption deed. Still the court recognized it. Of course, when there is no procedure as such, specific procedure as such, in the absence of such procedure, if the parties recognize and over a time they are recognized as the adopted child, I feel that it could be recognized as adoption. That is also what, as I said, is recognized by the district court. And under the Juvenile Justice Act, there is an elaborate provision. Even apart from going to the Child Welfare Committee, you can directly go to the court, have an order from the court to have an adoption.
Yes. Next question by Guru Prasad. Whether illegitimate child entitled to maintenance under section 125 CRPC?
According to me, under the section 125 being, it is not either for the Christians, Hindus or Muslims. There is no distinction as such. It is a general law. And as I discussed in that Kerala decision which I cited above, in that decision, it went in depth. What the illegitimate child has done, it is totally innocent child. If any wrong has been done by the parents, so why should a child suffer? So a illegitimate child definitely is having a right to life guaranteed under the Article 21 of the Indian Constitution, and definitely they should be entitled to the maintenance.
So I think with this we have completed that questions. So if anyone has got any other questions, you can ask directly. 2-3 questions it is permitted. Or else yes, sir.
See, regarding the single mother, the claiming custody, I think of recently some 2 or 3 years back, I think 2000, subsequent to after 2018, I think that is the one decision of the Honorable Supreme Court. I think where the mother wanted the nominee to be of the child to be entered, and the bank insisted the father's name should be mentioned. Then I think in that context, the matter had gone to the Supreme Court. I think you can search for that decision regarding the right of the unwed mother or the single mother without showing the father, because general most of the section says that guardian father is the first guardian, natural guardian. After father, the mother. Now, when in such circumstances where in situations where there is no husband, no father at all, or the father's name is not to be disclosed, or they do not want to disclose for any other reason, he might have been married in a child born in a living relationship. I think you better search for. I couldn't get it immediately. I think after subsequent to 2018, there is some decision
That
is
is-
that's a very useful decision and very apt. I think this would answer when hereafter we'll be getting mostly such cases only, where children
Just
born out of a living relationship, children born of a single parent. So all other things, I think I couldn't get that citation. But in that context, the law has been laid down. I think I would wish that all the advocates this one look into that.
yes, Mr. Guru Prasad has posted that citation. That is,
Yes.
unwed mother can be
Ah.
appointed as a guardian. 2015 Supreme Court online.
2015,
That
yes,
is,
yes,
yes,
2015, you are right.
509.
Yes, correct.
Yes, just now in the chat box, Mr. Guru Prasad has posted that
Yes.
message.
I think that will clarify the doubt regarding that. I think so.
Yes, thank you, sir, and thank you, Sri Guru Prasad also. Any other questions? Yes, or else we will conclude today's webinar. Now I call upon Mr. Nikesh Shetty to deliver the vote of thanks. Nikesh, ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಇಲ್ಲ. ವಾಯ್ಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ನಿಮ್ದು. ಹಾಯ್, ಮಾತಾಡಿ ಈಗ. ಇಲ್ಲ. ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಇಲ್ಲ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ನಾನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೇನೆ. ನಿಕೇಶ್, ಬಹುಶಃ ಇವತ್ತು ನಮಗೆ ಒಂದು ಉತ್ತಮವಾದಂತಹ ಮಾಹಿತಿಯನ್ನ ಕ್ರಿಶ್ಚಿಯನ್ ಲಾ, ಮ್ಯಾರೇಜ್, ಡೈವರ್ಸ್ ಮತ್ತು ಸಕ್ಸೆಷನ್ ಇದರ ಬಗ್ಗೆ ಕೇವಲ ಕಿರಿಯರಿಗೆ ಅಂತಲ್ಲ, ಈ ಕಾನೂನಿನ ಬಗ್ಗೆ ಯಾರಿಗೆಲ್ಲ ಮಾಹಿತಿ ಪಡೆಯಲಿಕ್ಕೆ ಆಸೆ ಉಂಟು ಅವರಿಗೆಲ್ಲರಿಗೂ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಕೇವಲ 1 ಗಂಟೆ ಅವಧಿಯಲ್ಲಿ ಸ್ಥೂಲವಾಗಿ ಈ ಕಾನೂನಿನ ಬಗ್ಗೆ ತುಂಬಾ ಚೆನ್ನಾಗಿ ಮಾಹಿತಿಯನ್ನ M.P.Noronha ಸರ್, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಮಂಗಳೂರು, ಇವರು ನೀಡಿದ್ದಾರೆ. ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ ಹಾಗೆ ಕಾನೂನು ಕುಡ್ಲ ವೆಬಿನಾರ್ ನಮ್ಮ ಗ್ರೂಪ್ನ ಪರವಾಗಿ ನಿಮಗೆ ತುಂಬ ಹೃದಯದ ಕೃತಜ್ಞತೆಯನ್ನು ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇವೆ. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
Thank you.
ಇಲ್ಲಿಗೆ ನಮ್ಮ ಇವತ್ತಿನ ವೆಬಿನಾರ್ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮುಗಿಸ್ತಾ ಇದ್ದೇವೆ. ಇನ್ನು ನಾಳೆ ಕೂಡ ಇದೇ ಸಮಯಕ್ಕೆ 4:15ಕ್ಕೆ ಇನ್ನೊಂದು ವಿಷಯದ ಕುರಿತು ಎಕ್ಸ್ಪರ್ಟ್ ಎವಿಡೆನ್ಸ್ ಬಗ್ಗೆ ಪರಮೇಶ್ವರ ಜೋಯಿಸ್ ಇವರು ಸರ್, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ಇವರು ಬಂದು ನಮ್ಮೊಂದಿಗೆ ಅವರ ಅನುಭವವನ್ನ ಹಂಚಿಕೊಳ್ಳಿಕ್ಕೆ ಇದ್ದಾರೆ. ತಾವೆಲ್ಲರೂ ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ಪಾಲ್ಗೊಳ್ಬೇಕಾಗಿ ವಿನಂತಿಸ್ತಾ ಇದ್ದೇನೆ.